Gav law. At Gavilaw script, dangerous dog, liability in Texas. If you've lost a beloved pet to a neighbor's dog and felt powerless watching animal control return the animal anyway, you're not alone, and Texas law actually gives you more options than you might think. This is a real situation someone faced in Texas, and it raises critical questions about dangerous dog liability, property rights, and how to protect your family when local animal control doesn't take action. Let's walk through your actual legal remedies. Your civil liability claim. First, the good news. You can sue your neighbor for the death of your pet, even if animal control returned the dogs. Texas recognizes what's called strict liability for dog owners under certain circumstances. Unlike some states that only allow recovery if the owner knew the dog was dangerous, Texas applies strict liability when a dog injures or kills livestock or pets on the owner's property, which is exactly what happened here. Under Texas Property Code Section 822.05, a dog owner is liable for damages if their dog kills or injures an animal, and the injured animal was on the owner's property at the time. You don't have to prove negligence. You don't have to prove the owner knew the dogs were dangerous. The law holds them strictly liable. Your damages would include the reasonable value of your cat. Texas courts have generally valued pets between a few hundred to a few $1,000s, depending on factors like age, health, and whether the pet had special qualities. You'd also be entitled to recover costs for fence repairs that were necessary because of the dog's actions. The dangerous dog designation. Second, you can petition your local municipality or county to have these dogs officially designated as dangerous or vicious under Texas Health and Safety Code Chapter 822. This is separate from animal control's recommendation. The fact that animal control already advised euthanasia strengthens your position. You have documented evidence of aggression and repeated escapes. In Texas, a dog can be declared dangerous if it has caused injury to an animal, has been previously found to be dangerous, or poses a threat to public safety. Once designated, the owner must comply with strict requirements: liability insurance of at least $100,000, secure enclosures, muzzles in public, and warning signs. If they don't comply or if the dog injures someone again, authorities can mandate euthanasia. To start this process, contact your city or county animal control office or your local justice court and ask about the dangerous dog declaration procedure. You'll need to file a formal complaint with documentation, photos of the fence damage, veterinary records of your cat, and the animal control report. Criminal charges and nuisance law. Third Texas Penal Code Section 42.092 makes it illegal for an owner to fail to control a dangerous dog that escapes and causes injury. Depending on the facts, this could be a Class B misdemeanor. You can report this to your local police department or sheriff. You might also have a claim for private nuisance. If the dog's presence and behavior substantially interferes with your use and enjoyment of your own property, which they do, given the threat to your child, you can sue for that interference as well. Protecting your child. Here's what concerns you most: your 7-year-old's safety. This is taken seriously by Texas courts. The fact that the dogs have a pattern of escaping, have already killed an animal, and are in your immediate vicinity makes this a genuine threat. Document everything. Take photos and videos of any aggressive behavior, keep records of dates and times the dogs escape or approach your property, and save all communications with animal control and your neighbor. Action steps. Here's what you should do right now. First,